a minute. I believe that Ms. Holt is going to be joining us. Okay. So just want to give her a second.
I mean, if you're taking the primary notes, why don't I give you that session?
Yeah, I think it's.
I have not 50%. I'm at 30.
I'll let you know. I'll let you know.
Yeah, just tell me. And then we'll give it to Austin.
What am I doing?
We're talking about the power.
Okay, yeah, that's fair. I do have a full
Or
charge.
you guys could charge your thing.
Yeah, I'm plugged in right now, but then Ava will take it and then we'll give it to Austin.
Yeah. I have a full charge. I just know after 2 hours of running Zoom, it will be dead.
Yeah.
So
We'll figure it out.
I have to wait until someone that's not GAU joins.
Yeah.
Okay, we should have everything set up on our end, but we can
Okay.
wait a couple minutes.
Yeah, just wait a minute or two to see if I don't think she has to be at a graduation right now. That's what she had said, but things may have changed. So I'll give her a minute.
I'm pretty sure there isn't one until 2, right? Except the one down in Harrell. I checked the schedule this morning because
Okay, I just know the people who graduated PhDs today
It was
in my
9 to
department
11.
graduated. I saw those photos and I was like, I don't know when the rest of them are.
yeah, it was 9 to 11, and then there's one in Harrell from like 1 to 3, and then there's one in O'Connell again from 2 to 4. They're playing for traffic.
No, my wife's never gonna go out to dinner this weekend.
No, you're not.
She wanted to go out tonight, and I was like, I've got a final exam at 5:30, 7:30, so it won't work out. I was like, maybe this weekend, and she was like, we can't do anything this weekend. Like, we'd be lucky to leave.
Maybe lunch
Maybe.
while everyone's actively.
Yeah.
Oh, I didn't even think about that.
Yeah.
I'm supposed to take my wife out tonight.
No.
Yeah, no, it's not happening.
Maybe
like Sonic
tonight.
or something. I don't know.
Maybe what?
Like Sonic, like a cherry. I don't know. I do.
She likes,
That's why I'm
does
like,
like a good cherry limeade.
I love the cherry.
That's her favorite. And we didn't have one anywhere near our hometown, so the fact that there's one in town here, she's like, can we go to cherry limeade? I said, all across town. She's like, but I'm like, all right.
Well,
all the way across town for a cherry limeade. You guys are recording it, right?
Yes.
Okay, so I mean, if nothing else, if she pops in, great, but I haven't heard back from her own team, so.
Yeah, I've got all the participants up, so as soon as she's in the lobby, I'll
That's
add
fine.
her.
The big thing is just that we can, if she could.
There's Becky.
Look at that, timing. Send these over to you. We got 4 today.
I recently found a trash can in my department that has a with love sticker on it. And I thought that was really funny. It's like in the printing lab. Super random.
What you're in turn?
Just like in my department's printing room, there's, a regular trash can that had a sticker.
That's pretty good.
Like, I don't know who did that, but it is funny.
Okay. All right, we're gonna start with number 8.
So actually,
Oh yeah, go ahead.
we do have one proposal, and
Sure.
I actually kind of have to leave a little.
Go ahead.
I mean, these guys can be here till the end of the
That's fine.
But so I think, yeah, we might as well start with that.
That's fine.
We'll just.
Leaves of absence.
So this is our counter for Article 16.
Okay.
Actually, I better save one.
Do you want one since you're?
If you got a spare, thanks. We can share.
He's
You
a cool-
need
I'll
one?
pull it up on my computer.
Actually, we can share. You need one of that? Or
No,
should-
no,
okay,
no,
okay.
please. I got it. I can pull it up on email.
Okay, so there's essentially two main points here.
Right.
I think you'll see obviously that we have reinserted current contract language of the for the release time provision. We've also increased our FTE to 5. As you know, I mean, I think we were willing to make concessions on the number of FTE. We had actually said 4.5 in our previous proposal, but given that your last two counters have essentially stricken out current contract language, we consider that to be kind of a regression in the negotiations. And we already gave the concessions in terms of reducing the number of release time appointments and also taking out our demand for being able to hire a person who has not officially received an appointment. But given that you've come back with two proposals, you know, striking it out completely, offering us nothing in return, we also will have to go back on some of the concessions that we've made. And honestly, if you keep bringing back those proposals, I mean, we'll probably end up right back to square one. So I really hope we can avoid that. But yeah, that's essentially, I mean, our proposal here is the same as our last one, except we increase our FTE by 0.5. The other point that you should notice is in 16.5. We've changed our previous demand with regard to the parking. Essentially, what this insertion would mean that GAU gets a commercial parking permit, and you can see the link that I provided there, and essentially a commercial parking permit with service drive privileges. And you know, it would follow the same rules in terms of like for the service drive. I think the service drive permit is given for 1 hour. You have to write a letter about it or something like that. I think, you know, we can follow those rules.
And that's the because I know there's multiple different types of it. That's the specific one is the one that you have linked here.
Yeah, that's right. Yeah.
All right.
So yeah, those are the two main changes there.
Any questions from our side? Okay, thank you very much. All right, hopefully in that 3 minutes, hopefully you were able to get the email that I sent that had.
I did.
Okay, good. All right, let's start with number 8. So I think we're getting really close on this one, and hopefully this will, if this doesn't get it completely done, hopefully we're really close. What's up? No. There shouldn't be much change. 8.1, I think we've clarified the fact that there was some back and forth about whether or not, I think it was parent maybe that we had gone back and forth on, that this should read, everything in 8.1 should be stuff that we've already sort of agreed to and discussed. 8.2 should be similar. Again, I think, I can't remember if it was, I went back and tried to make it consistent between GA versus employee. So if you'll notice, the only changes you should see in 8.2 and 8.3A are, again, just changing employee to GA to make it consistent. At the end of the day, when we go to put it in the final book, if we want to do one more time and just like, let's make it consistent through all the articles, because I made it consistent with internal to the article.
Sure.
But I didn't go back and check all the other ones, because I think in some places we say GA, in some places we say bargaining unit member, some places we say employee.
Right. Well, I mean, actually, I mean, in the definitions article, employee is already defined as
Okay.
a bargaining unit member.
Okay.
So it may not really matter in the end,
Right.
but yeah.
just for the
That's
sake
fine.
of
Yeah.
it being consistent and,
Sure.
you know, whatever. So that should be it on, page one. When you go to page two, I think we had discussed, no, that one we already did. So, down to 8.4 is where we've inserted now a separate, taking it out of being one of the reasons listed under the other provision, under paid leave, and instead inserting it as its own provision inside of the article. So what we're suggesting is bereavement leave, GA should be entitled to 2 days of paid leave upon the death of an immediate family member as defined in 8.1 above. And then we heard what you said, and we know that you had somebody come and sort of speak last time. In the event that an immediate family member resided internationally at the time of their death, the GA shall be entitled to 5 days of paid leave, 5 paid leave, bereavement leave in addition. And then the next sentence, bereavement leave is in addition to the personal time and paid leave provisions above. Taking bereavement leave does not prohibit a GA from applying for either paid leave or unpaid leave in accordance with other parts of this article. Any additional leave beyond the limits described in this provision must be in accordance with either 8.3 or 8.5. So, you know, again, I recognize that initially, you know, it appeared that GAU wanted to access the entirety of the 8 weeks for the purposes of bereavement. I think we acknowledge that it shouldn't necessarily, the initial component shouldn't necessarily count against that, nor should it necessarily count against the 5 days, because we understand, we heard you say that was limited. So is there a special case for bereavement? I think we agree and acknowledge that, yes, this is a special case that deserves its own category. We don't want to stand in the way of if someone, you know, is certainly suffering from, you know, the need for seeking their own health services as a result of that event. Absolutely. We don't want to stand in the way of preventing them. We try to give an explicit statement that says, look, beyond that, absolutely apply for paid medical leave, and or if it's not a medical thing, but maybe you're responsible for, you know, there was some discussion about if you're the executor of the estate or you have to travel to deal with property and things of that nature. I don't know what it's referred to in various other places. You know, you certainly should be able to apply for unpaid leave. I think the university's position is that in those cases, we're just not convinced that if you have somebody pass away and you're the executor of their estate, whether or not we should be forced to pay paid leave for you to engage in those activities. If that's not something we do for any of our employees, is to give paid leave for being, you know, managing the estate in the event of somebody's death. So I think that's kind of the critical change. Or the significant change. If you look down throughout the rest, I don't believe we made any other changes through 8.5. That should be the same as you saw previously.
There's that requisite, we changed the name of the leave.
Oh, you're right. I appreciate that. So there was some discussion from our leave team about the term of what the name of the form is in 8.5. And there was some discussion about whether or not it would make sense to have the same form or different forms. So we just changed it to say the requisite leave request form, meaning if it's the same form, fine. If it's a different form, that's okay too, but it needs to be on the right form. And then, yeah, that should be the changes. So happy to talk if you have questions or want to talk.
Yeah, I have a few questions.
Yeah, go for it.
So is it your attention that the bereavement leave does not have any of the restrictions that the paid leave have? Like they have to be like in their second semester, things like that, or does none of those restrictions your attention apply?
Yeah, because we pulled it out of 8.3, you know, our intention is that those restrictions are specific to 8.3, and this is outside of that. So
Okay.
The way it's constructed, you would be entitled to that, you know.
Or 8.2. Oh, okay. I see the numbers are 8.2. I guess 8.2. It's showing like in brackets like 8.3 like on the online version that I'm looking at, so sorry. Or at least the one you sent. Okay. And yeah, that was really the I just wanted to make sure like that was separate.
I have a question.
Sure.
Days are kind of fuzzy, especially for like a teaching assistant. I mean, I think it's probably more clear for a research assistant where you're likely working 5 days a week, but we work on hours kind of, right? Like, so what do you mean by 2 days or 5 days? Is that if I work 8 hours a day, is that 16 hours? Is that 2 days where I'm teaching? Is 5 days a full work week? Like, I'm just wondering, like, what does that mean?
So we were using the way that it's described in 8.2. We weren't
Okay.
doing it on an hourly basis because we didn't talk about a bank of hours. We talked about it in terms of days. So,
Okay.
I mean, we can make that more clear, I think, but I think our intention is not to have one type of leave use one type of hour interpretation
Yeah.
and another type of leave use a different. I think that would just make it extremely confusing.
Yeah. I just think when it's, and the personal time is weird too,
Yeah,
for the
that's
exact same
completely- yeah,
reason.
yeah.
And so when it's weeks, it's clear, right? You're talking 6 weeks, 8 weeks, that's
Right.
a real set of time, but days is really fuzzy for us.
Yeah, I mean, I
go
think the larger point here is like, when Olga described her experiences
Yeah.
last time, I mean, the time that she described was like a roughly 5 week period.
Right.
To, you know, from start to finish, to be
Mhm.
able to go to her home country, take care of all the matters that need to be
Right.
taken and come back. Frequently when people take this personal time kind of day, I mean, what ends up happening when you TA is that you come back and then you often have to make up the time that you miss. Like whoever filled in for you, you go and fill in for that person. So effectively, it's not really like time off at all. And again, if it's only 5 days here, I mean, it's gonna be essentially in practice gonna work out the same. So yeah, I mean, I think the major concern here for us is, I think we're fine with having a separate provision. I think that makes sense, especially given that the rest of the provisions were kind of tailored to what's in the faculty contract and
Right.
what's in FML. So I think it makes sense to have a separate provision. I am concerned about how short that time period is, and I'd ask you to consider, like, what would you do, right? Like, you know, how many days would you take off if like a close family member of yours?
So
Yeah.
I don't have a problem sharing
So,
my personal
yeah.
experience if you want me to. I mean,
Sure.
sure. So I was actually, I was working my father passed away about probably 10 years ago. And I was the executor of his estate. And I left work. I got notice on a Wednesday that he passed away. He was in California. I was working in Southwest Florida at the time. I used, we did not have, in my previous employer, we did not have a bereavement leave provision of any kind. So I took Thursday and Friday off. I used personal time on Thursday and Friday, and then I took the next week. And I came back the following weekend, which was after we had his service. I used a combination of sick time and I don't remember if it was sick time or vacation time because I accrued sick and vacation time. And then there was a period about 2 weeks later where I had to take another 3 days and go back.
So how many weeks is that?
I didn't take it all at the same time. Like I said, I came back and then I flew back out to California one more time, I believe.
Sounds like about 2 work weeks, right? If it was like 2 days. plus
2 days, 5
plus 3
days. Yeah.
Right.
Right.
And so, and then you have to take into consideration, we don't have, you know, paid time off. We
Right.
don't accrue paid time off.
Right.
And the other part is that, you know, half of us are not, it's not just like a flight across the country, it might be a flight across the world, right?
Right.
So those are our considerations. And I think we're fine with this provision. It's more just the amount of time.
I mean, I get that. I think that what it comes down to is going to be a balance of whether or not it should be a paid benefit versus access to a benefit that is not paid. I think that's really what it comes down to. What is the amount of reasonable consideration for someone suffering, you know, the unfortunate event where they have a death in their immediate family? I will tell you that, and I'll kick it over to Robert to verify. I think if we were to do it this way, this would be the only group that's given 5 days of consideration for international. I mean, does anybody else get that? No. So, I mean, I do think that in some respects, I appreciate what you're saying, that you don't necessarily feel it's generous. We feel it's an opportunity to recognize that there are people in the bargaining unit that may have that struggle. I think the question then becomes how much of that should be the university's responsibility to pay for versus a response to say, look, we're going to protect your job, but we're not going to continue to pay you as if you were working while you are taking care of that. I think that's where the balance needs to come in between where your position is and where we serve.
Right. And I think another thing that Olga spoke to last time is the kind of the, you know, subjective experience of feeling that your employer does not care about the fact that a loved one has passed away,
Mhm.
right? And you know, I find it hard to say that, you know, giving 5 days would like go a long way to kind of ameliorating that feeling. So and you know, again, who I'm not sure what other employees you're comparing us to. I mean, the faculty is the most comparable kind of set of employees, where in terms of like how many people you're getting from other countries and stuff like that. Um, you know, and they get paid time off. They get accrued paid time off, right? Like for them, getting leave specifically for bereavement is not such a high priority because they can do the types of things that you describe, right? In your case, we can't do that. So I think that that's the real issue there.
I do think you can access leave, though. The question, again, it comes down to whether or not that leave is paid. I mean, I think that, I mean, we weren't able to uncover any cases. We had some questions. I went down and talked to the leave team. We have had a couple questions about people saying, look, how does this apply to me? I have to travel internationally. But we couldn't uncover any cases where we had either where we had terminated someone or anything like that. I think there was one question. Obviously we met Olga, which was a sort of an actual example, which was, you know, that was insightful and helpful for us to hear from her. Are you getting a sense this is coming up a lot?
Actually, in the last couple of months, it has actually, someone in my department also has suffered the same thing. And I remember there was another case that came. I think
Yeah,
there was
I feel
another
like
case, yeah.
we've heard from like 3 people within the last like
Yeah.
month.
And they feel like well, I guess you wouldn't know because it's not on the books, but accessing the unpaid leave is.
I mean, I don't want to go into their specific case. I
No,
know
I'm not
about
asking
only one of them.
specific,
So
but
yeah. I mean, I'll stick to the one that, you know, who
Yeah.
felt comfortable
I get it.
sharing her story. But you know, I don't think it's that difficult to imagine why someone might feel that way, right?
Sure.
Yeah, I mean, I think we'll give you our response in the next
That's fine.
proposal. I mean, how do you feel? I mean, the way you described how you took your paid time off, Patrick, was like kind of a combination of paid and unpaid, right?
No, I had been accruing time.
Right.
I'd been with the same employer for 11 years at the time.
Right.
So I had been saving time up in case something happened.
Right.
Yeah.
Okay. But it was all paid. Is that correct? Okay. All right.
Oh, I just thought of something and then it immediately left. Wait. Come back to me.
And I think one of my concerns here as well is that, I mean, you're talking about paid versus unpaid and like, you know, if it's the university's responsibility to pay when a tragedy happens like this. And I think one of my issues besides, you know, talking about how short the leave here is that the process for the unpaid leaves, you know, is up to the university to accept or deny. So there's no guarantee that you even get anything after like 2 days. And I assume in most cases, the university would be like, you're fine to take those
Sure.
extra days, right? But you know, that's no promise to anyone that they can have those extra days. They still have to, you know, make a request no later than 10 days from the start of the period, unless this counts as a medical emergency, which we aren't clarified that it is. They have to give a verbal notice. How's that going to work if they're international? And they're 12 hours out of the way of someone else. You know?
They also can't be in a second semester or a first semester, I mean,
Yeah,
for the
so
paid time.
I would have I, as someone reading this and understanding the discussion thus far, would, you know, be concerned and worried about at the very least the extra stress that would add on to extra people to get that process figured out. And I think my concerns here come secondary to our discussions by default of how long this period is, because I think a longer period alleviates those concerns. But I think that's something else we're probably gonna have to talk about and try to figure out as well.
Yeah, I think what we would be interested in hearing from you all, and I think one of the things that we've been really focused on in our conversations is really effectively separating the medical needs of the employee who is experiencing this event from a specific type of leave, which is granted solely for the purposes of typically attending a service, which is really what bereavement is about. It's really not intended by definition to be about personal, you know, medical or mental health needs or emotional needs surrounding the event of a death. That's really not what bereavement is for, other than like the immediate day or two. I don't know, and maybe there are longer bereavement policies, but like I said, I had time accrued there was no bereavement policy. I mean, many employers don't have a bereavement policy. They tell people to use their accrued leave if they have it. Obviously, this is a different situation. You don't accrue leave. You know, you only have the 5 days per semester. So I realize that it's different, but there are many employers that it's a day, like you're allowed to attend the day of the service. Maybe there's 2 days. So I think we'd be interested in just keeping those things kind of separate. And if you have an interest in, again, keeping in mind, like, what's the part for actually attending the service or connected with the actual event itself? And then what is more about the employee's response or emotional, mental health and emotional needs as a result of the event? I think we would like to keep those things clearly separated.
I think that was what my question was, right? So it seems like based on what we have for paid leave, that they wouldn't necessarily be eligible for adding paid leave onto the end of a bereavement because it's probably not a personal medical issue or a child or one of these things. So it's really coming down to unpaid leave. And I just wanted to clarify clearly, would they even be eligible to apply for unpaid leave?
It actually explicitly says you can apply
Because-
for either. Our intention was to make it
Okay.
explicit that you could apply. It says you're not prohibited for applying for.
So how, if we've limited paid leave to these 5 options, then how would they apply for paid leave? Is it just a special clause coming through the bereavement that they'd be able to do that?
If they're experiencing a mental distress and anxiety or depression as a result of the death, then they can apply for paid leave.
Okay, so that would be the only situation.
Yeah.
Okay.
Well, I think that's the one that's probably the most logical, right? Like you experience that type of a tragedy,
Right.
would some way, shape or form affects you
Yeah, or if you were
emotionally,
for the family member before they pass, that would also potentially qualify, you
Right.
know,
Mhm.
so.
leading up to the event.
Yeah, I mean, I don't think there's unpaid leave. Can they take that the first semester? I don't see a limitation on that semester wise, is it?
I mean, I think we can request unpaid leave whenever we want, right? I mean, that
Yeah,
doesn't mean
this, yeah,
but-
Yeah, I think. paid
it's
is
a
just-
request.
Yeah, but unpaid is.
Okay.
Yeah, I don't think there's any, I don't see a limitation.
Mhm.
No, there's no limitation for the unpaid leave, like having to be like in your second semester or the other. Thing.
Right. Okay.
Is there anything in the comments that you wanted us to take note of here, or?
I don't think so.
These were just talking about the
Yeah, this was,
forms.
yeah.
Okay. All right, is there any other, Nathan, you wanna add anything? Okay,
No,
All right.
that sounds good.
All right, can we move on to 28?
sure.
Thank you.
Oh, crap. Hey, let me see, I give you the wrong one.
Give me the wrong one.
Didn't you say 28?
Yeah, but this is the wrong version of 28. The older version of 28.
Did you send me the right
I
version?
don't think I did.
Oh.
You folks are sure you put them all in one page
This is that we need to
without
take
like the
out, like
signatures and
my,
everything.
like my proposed changes were still in there.
Well, I guess.
And then, like,
The ones I deleted. What's the?
Well, this, like this. Oh, wait. This, like, all this stuff is mine.
That wasn't part of the previous thing?
Yeah.
I thought that was part of the previous one.
Well, there said something like. um,
That's right. This was part of the previous proposal. That's crossed out. This was language I added
Is this the one you're saying?
after a conversation.
Renting implementation.
This.
I
Yeah.
added that this morning.
Yeah.
Oh, I think this is right. Let me send this. I think this is right.
I mean, this is the one that he sent us, but I don't think it's the right.
No, it's not. Let me send you the right one right now. Sorry about that.
Mhm.
Sorry about that. It's coming back. They'll be getting it. I should say correct one on it.
I didn't think this, it doesn't show all the track changes, but it's more online, it just generates a PDF, and it's weird, it'll show some things, but not all of them. Yeah.
And how was your
I can't
power
tell.
line?
I'm at 74, so we're doing all right.
On it?
Yeah, I mean, if you guys are both good.
While we're in this, like. Nothing is open.
All right.
Okay.
Yeah, sorry about that. Would you mind putting it up there?
Shouldn't be essentially the right one. You could-
It's close, but there's a couple, I think it maybe comes down to just a couple words, but. And I think that you're gonna see
I'll do
that
it.
we made some changes to the language, but I think we were attempting to clarify the intent, and I think the intent is unchanged in
Okay.
terms of our discussion. You know, we've really kind of focused on
You get it.
individual words on this one. We've gone back and forth, and it's a brand new article, like it
Mhm.
currently doesn't appear, so we want to make sure we get it right. So when you look down at, it's really B, because A, I think we've left unchanged for the last 2 or 3 sessions for the most part.
Right.
When you look at B, so this is in the case where the university adopts a new regulation or amendment to an existing regulation, policy, or resolution that has a direct and substantial impact on wages, hours, or any other term and condition of employment of employees in the bargaining unit that isn't covered in case A, which is we're compelled to do it because of some overarching legal requirement, court, you know, something that's not forcing us to, but the university goes ahead and makes that change. So in that event those are the cases we're discussing, the university shall satisfy any collective bargaining obligation with respect to the change prior to implementing it. UFF GAU must declare in writing whether it chooses to, and then we change the wording of all of these, but we think that it now is clear and we believe the intent is correct. The first option you all can say in writing is you want to reopen the relevant articles of the contract and engage in bargaining. The second one is you decline to reopen the relevant article of the contract until the end of the contract period in accordance with Article 23, preventing implementation with respect to employees in the bargaining unit. And then the third one is you could choose to waive the right to bargain over it regarding wages, hours, terms and conditions of employment, allowing the implementation of the regulation, policy, or resolution with respect to employees in the bargaining unit. So again, I think one of the things that we kind of kept getting tripped up on was impact, which has there's kind of a big I impact and a little I impact. There's a practical impact of a change versus impact bargaining, which is its own process. This is describing a situation that wouldn't necessarily be impact bargaining. I say necessarily because there are cases where it could be impact bargaining. But again, by making it clear that you all have the option to either choose to open it, choose not to open it and refuse to allow us to implement it, or waive the right and allow us to implement it, we think kind of contains the cases with making it less confusing. The intention was to make it less confusing.
In what situation would it be impact?
In what situations?
I mean, if you're taking like a discretionary change to regulation or policy, that's gonna affect wages, terms and wages, hours, and terms and conditions of employment.
Right.
Then, I mean, how would that, I mean, and we agreed to open that, right?
Right.
We would be bargaining the substance of it, right? I mean, we wouldn't be bargaining the impact of that kind of change.
So
Otherwise, you're unilaterally taking a decision about.
right. This is to address your concerns about us being able to unilaterally just say, well, it's in the policy now, so you guys don't have a choice.
Right.
Like that's what this whole thing is attempting to speak to specifically, to say, if it's compulsory, if we tell you it's compulsory because we're being forced to make the change.
Yeah.
But if it's not, then you all tell us, okay, we'll go ahead and bargain it. We're not going to bargain it. You have to wait until the next full book,
Right.
Or we don't want to bargain it. Go ahead.
Well, I guess, I mean, the question I was clarifying was you were saying that in this case, it would not be impact bargaining, but there might be some situations where it might.
It could be.
Like where?
So,
Like
I
how?
mean, it's impact bargaining if the policy or regulation relates to something that we have a managerial right to, which in those things are delineated in the statute.
Right.
And then, but sometimes those things that we have a managerial right to do could have an impact upon your terms and conditions of employment. Like say, I don't know, let's think of a decision off the top of my head, but maybe we make a decision regarding the hours that buildings are open or something, and then that affects the hours that you work or something, you know what I'm saying? Like we have a managerial right to manage our facilities, but then maybe that policy or regulation then has an impact upon the conditions of your employment, in which case you're not bargaining
The change, the
decision,
managerial change.
right?
Yeah.
A managerial
Yeah.
change, you're just managing the impact of that.
Okay,
So we wanted to make sure the language kind of covered both of those things.
okay.
So like if it was directly regarding your terms and conditions of employment about, you set like a minimum wage or something like that,
Mhm.
then there's then that's the issue that we're bargaining.
Right.
If it's, the impact, then we're bargaining that too. We just wanted to make sure that this covered both of those situations. So we just kind of used broader language.
I get what
about-
you're saying.
You see what I'm
Not
saying?
that-
Because we didn't want it to like be read as it only applies during impact or it doesn't apply during impact and.
No, I appreciate
Yeah.
that. It's been-
So-
Yeah, thank you. Any other questions, guys?
I think the only language thing is, can we just take out the wages, hours and terms and conditions in that final part? Cause isn't it just redundant in the top? Like it says it in B, but then in B3, you have it again. Talking about clarity, right? It's waive the right to bargain over
The changes.
the wages, hours and terms and conditions of employment, allowing implementation, like, we're already talking about wages, hours, terms and conditions.
I mean, I guess it makes sense in the sense that if we were to bargain over it, those would be the things that we're bargaining
Yeah.
over.
Yeah.
Mhm.
But,
It's just
like
already-
in the situation that Olivia described, if we were bargaining, those would be the things that we're bargaining, not the management, like whatever decision they've taken at
Right.
a managerial level.
Yeah. I just mean literally like having it
In
in
there.
3 is
Yeah, I mean, it
redundant
doesn't
because
make a
it's in
difference.
B.
I don't.
Yeah,
Yeah.
maybe when we see it cleaned up, it'll.
Yeah.
Maybe it'll flow a little bit better.
Okay.
I know we've chewed on this one pretty good. I mean, are there any other like major hurdles? Do you think we kind of maybe got close to the mark in terms of making it clear? Do you guys want to kind of take it away and think and talk about it? I mean, I think
I think we're
we
pretty
keep getting
close,
closer on
Yeah.
this
Yeah.
one.
I think we're all on the same page with
I
what
think
we're
so,
doing. We're
yeah.
just trying to make sure the language is clear so that when you guys aren't here and then when maybe one of us aren't here, school welfare also is looking at the agreement, they understand the intention.
Mhm.
Yeah, I think we'll talk it over as a group.
Okay.
But I think we're pretty close as well.
Okay. You want to move on to number 9?
Sure.
I checked the other ones. I think we're good. All right, so this one's gonna be a little bit more of a mixed bag. Okay, looking down at the first, I think 9.1 is the same, and 9.2 is the same. Now down in 9.4 is really where we're gonna start seeing some differences. So you all had proposed the last two sentences from 9.4. We have agreed to the last sentence of 9.4, which is the one in the research. GAs are permitted to maintain and publish their opinions and conclusions relevant to their domains, but not the one starting in line 30 in the classroom relevant subject matter. We're not interested in a test for really what's above that. We think that the language described in the first part of 9.4, sort of speaks on its own, and we don't really want to get into, again, creating this sort of legal test of
Well, you
whether it's
already are.
relevant or irrelevant or whatever.
Sorry, I didn't mean to cut
No,
you
it's
off.
okay.
Yeah.
Good.
Well, I mean, by saying that you're free to discuss relevant matters in the classroom, you already are creating the test in terms of
Right.
relevance.
Right.
Yeah. So there is a test that has to be, like
Right.
something has to be established that it's relevant.
That's a fair point.
Yeah.
I don't think we're interested in further constraining the test beyond what the reasonable word relevant is intended to mean.
But that's the issue for us is it's a nebulous term, and for us the negative definition helps to put in a protection that I think that adding the word relevant, it adds uncertainty in terms of what counts as relevant and what doesn't count as relevant. And that's why that sentence is in there, because there may be students who might be offended by a particular remark or whatever, but that doesn't make it irrelevant, right? So that's kind of that's kind of what we're trying to get at.
Yeah, I think I understand the intent. I think, and I'll ask Olivia to correct me if I'm wrong, if I don't say this correctly. I think that we don't agree with the assumption that just because a student fails to perceive a clear connection to the course description, that makes it automatically irrelevant. Like, I think that assumes that that's the university position. That's not our position.
No, I know. Yeah.
I mean,
I would hope not.
Yeah. That's not the way, we don't, there's an entire process. For example, if we believed one of our GAs were to violate this, while we may interview students in the classroom, them thinking that would not necessarily meet the test of whether or not someone was responsible for violating this provision of the contract.
So what would meet the test? I mean, like, what is the policy or procedure?
Well, I think it would go through it would be the normal investigatory, people would be afforded their normal due process consistent with, investigations and administering discipline. I don't know, Robert, if you want to speak to that at all about, I mean, people are afforded due process. They've been accused of violating one of the components of the CBA.
Yeah, we talked about this before, about like what notice looks like and what the process works. So if you have any questions, I can answer them. I feel like we've talked about that in other sections.
So it would be handled through a disciplinary process, which would be subject to grievance and so forth.
Right.
But again, I mean, that process doesn't specify the test that you're talking about in terms of what counts as relevant, what doesn't count as relevant. When you're doing your interviews, like, okay, fine, if a student says it's not on the syllabus, therefore it's irrelevant, you're not going to accept that as a reason.
What are they being investigated for?
Like say in the instance of like a student being offended by something that has been said in the classroom, and they feel like because it's offensive to them, that means it's irrelevant.
Well, so I will say there's a law that prevents it's called shielding. So we can't shield our students from unpleasant topics. There's a state law that says that. So, we wouldn't likely investigate something like that unless what was said was violated another section of the regulations, like it was harassing or, something along those lines.
Yeah.
So, in which case this wouldn't really be the provision that they would be investigated under, or they'd be investigated under, those other provisions regarding,
Right. I mean, what I'm saying is that in such a case, I mean, if we were to defend that person, right, and we felt that that actually like academic freedom means that that the GA could say that in that class without being discriminatory, right? Like, I mean, I think that that's kind of the situation we're considering.
How does that interact with 999 and all of this stuff where students can report instructors for saying stuff and you're not allowed to talk about white privilege or male privilege, or like, how is this shielding? You know what I'm talking about, right?
Yeah, I'm.
Or I
not
guess it's
getting, like,
266,
what is
not
the-
999.
Oh, okay, the interaction between
Well,
those two.
Shielding.
Well, that you're talking about HB7, which is currently enjoined.
No, I'm talking about 266.
266,
Sorry, which was
regards to-
complementary to 999, which also had the DEI stuff in it.
Okay. And it's like, it has to do with like gen ed courses and that sort of thing.
Yeah, it was
Yeah.
the one that said that well, I'm in sociology. It's the one that got rid of the core designation for principals. And it also says that we're not allowed to say like any group or identity like has like rights or privileges over another.
Yeah, I all I can say is that those are two different laws that our state legislature passed.
Okay.
And so, you know, the shielding law is kind of broadly, I don't have it in front of me, but it kind of broadly says you can't, and that was passed before the other law.
Okay.
So, you know, I'm not sure, I can't
Do you
say.
know what that one, the shielding one is called?
It was HB 233. And that's the same one that talks about the class reporting, which we
Mhm.
also,
Class recording.
I thought that was HB7, is it not? Okay.
Yeah,
Okay.
so
I just am curious.
it's a valid question. I just don't have an answer to it.
Okay. It all gets into that relevant and what people are offended by, because if I say in my class, white privilege exists, which like I have data to show, right? Which is scientific.
Mhm.
And that's like one of the things they're like, it can't be opinion. It's like, okay, well, I have data.
Right.
But if I offend someone in my class, they can report me to my like head, like my department chair. And then there's a whole process that they go through. It goes to him, then it goes through like the ombuds or whatever office. And so that's interesting. I didn't know about the shield. I've never heard about the shielding
Mhm.
thing here.
Yeah, that came out like two sessions ago, I think,
Okay. Thank you.
but I think it's part of the Campus Free Expression Act, maybe. Don't
We'll check on it.
quote me on.
Yeah, we'll check. All right, 9.5. Academic responsibilities of the GA. I think A and B, you've seen that language before. Academic responsibilities of the university. Academic responsibility implies the competent performance of duties and obligations and a commitment to foster within the university a climate favorable to the responsible exercise of academic freedom. Therefore, it is a responsibility of the university too. I think that for the most part, what's
Oh,
the matter?
remember we had changed this language, is that not?
What?
I'm sorry, I just cut you off. Remember we had tried to change this to make it
I
broader.
put it right here. It's here.
Oh, okay, sorry.
Yeah, no, I got it. That's what I was about to start going over.
Sorry, it just wasn't in a different color, so that's why.
Yeah, no,
I
it was the
got
same
worried for
color
a
because this
second.
was my language originally. So when I changed it, it just showed up the
I was
same.
like, oh, I just
So,
don't trust it.
no, we did. No, we got it. We got it. So starting down in, we had gone back and forth. The highlighted section in your comment there is in line 56 about recording class discussion without permission.
Mhm.
So what, there was you had suggested, recording class discussion. So what we actually did was based on your comment and what you had suggested, we reworded it and said, look, let's go ahead and include not just class discussion, because as you pointed out, there was other stuff.
Right, yeah.
It talked about lab, like student participation,
yeah.
performance, like it talked about other things. So what we just said is inappropriately recording portions of classes in violation of university policy and Florida statute. And the statute you reference is where it talks about those other things.
Okay.
So, I mean, our intent is actually to broaden your request to include not just that, but all the things that are protected by state law to be whatever, to your point. So,
To be
yeah, hopefully,
not recorded.
yeah, to be, yeah, prohibited from being recorded without permission. So hopefully that's that meets your expectation, hopefully. And then, the rest of that section should be unchanged. I think when we get to 9.6, which I think we've kind of gone back and forth about, we're not interested in your 9.6, but what I'd like to do is kind of point us back at 9.1. And if you look at 9.1, specifically to lines, it starts in line 6 the freedom to discuss all relevant matters in the classroom, and then to explore all avenues of scholarship, research, and creative expression, to speak on all matters of university governments, but then here starting in line at the second half of line 6, I believe it is, and to speak, write, or act as an individual, all without institutional discipline or restraint. And I think that that really is kind of at the heart of what you were attempting to say in 9.6, is that you've got this persona that's an employee, and you have this persona that's an individual. And there are places where the two overlap, but there's also places where the two are discrete and distinct. So, and we believe that to the extent that we're comfortable with recognizing that, we really prefer the language that's already sort of right in the first provision, as opposed to having a separate one that sort of calls it out the way you've written it. But we recognize and we believe that that is sort of, we think it's already baked in. And to be perfectly honest, we're not comfortable with some of the very specific language that you all have.
Well, yeah, can you go into that a little more? What specific language?
So, I mean, the first part is basically almost identical.
Right.
I mean, if you look at lines 75 and 76, that's pretty much the same thing.
Right.
I don't think we agree with the statement that an expression of opinion as a citizen cannot constitute grounds for dismissal or non-renewal. We believe there probably are some cases in which that's true, but what we don't want to do is get into all of the caveats and all the swinging doors regarding the intersection of First Amendment rights and employment management rights. And we think that a more broad statement that acknowledges and, you know, contains the fact that you are free to speak, write, or act as an individual without institutional discipline or restraint. So at that point, it becomes incumbent on, in terms of a violation, you know, effectively, and again, I'll defer to Olivia to correct me if I use the wrong terminology here. At that point, we would have to say that your actions go beyond just being an individual, but also affect your employment.
So in what context would an expression of opinion as a citizen constitute grounds for dismissal?
There's so much case law on the intersection of First Amendment versus.
Yeah, and I mean, there's tests for determining when you're speaking as a citizen, when you're not speaking as a citizen, whether it's a matter of public concern, whether it's like, so I think to try to shrink it down into like a 2-sentence statement in the CBA is not going to capture all those circumstances.
I just don't see how, I mean, you can, I mean, so, okay, we're saying a person should be able to speak, written, write, free from institutional restraint.
Right.
But also an expression of opinion could be ground for dismissal.
Depending on the specifics of the case. I mean, I think there are specifics where people have taken the way that they share the opinion, how they construct the opinion, the way they promote the opinion, how they declare they're speaking. There's all these things to say emphatically, no matter what, it can't, is just a statement that's too strong for us to be comfortable with.
Well, I mean, so the first part of this provision, right, is the part that's already in the CBA.
Right.
But then if all of those other things have to be taken into account, whether that person is subject to institutional restraint, then they're not free from institutional restraint.
What about like a hateful opinion that suggests violence against a group of people?
I mean, what are the speech laws in the United States about that kind of?
Well, you have the right to free speech, but with that is limitation. You can't scream fire in a crowded theater. You can't be defamatory towards someone else. You can't elicit a mob to go take down, you know, a Starbucks, right? So there are limitations. Free speech isn't completely free.
Right.
So you can have an opinion that could cross over into an act that is no longer protected as free speech.
I mean, and then it's not an opinion, right? I mean,
No,
like if you're telling people to go and
my opinion is that this person should die.
I'm confused with
It's
the
extreme.
hypothetical.
It's extreme.
Yeah, I'm giving an extreme example.
Said in a classroom, said on social
Well,
media.
that's exactly the
said
point.
in a-
Like,
yeah.
like there's different forums, there's different
Yeah.
locations, was there any kind of implication that you were stating as in your position and role as, you know, a representative of the university? There's all these factors that are taken into consideration, which is why I was saying to have just kind of like a 1-sentence statement in here that it could never subject you to any form of discipline is just, I don't think encompasses all these. Whereas I think the general statement that's already in 9.1, I think like addresses that without having to get into the negative, the inverse of that.
Yeah, I mean, again, I think for us, like the negative is the important part because, I mean, what you're saying is, oh, well, the positive is good enough, but there are all these other cases where it's too complicated. We can't have two sentences. Okay, let's like write 20 sentences about it. I mean, like,
But why?
why not? I mean, like, because it's not, I mean, because from the way you're describing it is like, there could be a plethora of instances where actually you could be subject to institutional restraint. And all of those reasons are also could potentially, be used in a way that's not fair, right, as well, right? So I think it's fair for us to like demand that those instances be specified explicitly,
Well, if you want to try to do that, you can, but we're not going to agree to anything unless it's a 100% exhaustive list.
Okay, I mean,
so I mean, to me, it's like, because then you get into the point where if you don't put something in there, then it means you purposely left it out. And then then we're left in a position of trying to come up with every single scenario. And I don't think
right now
that's not the purpose of contract law and making a contract that you can actually enforce.
Okay, well, I mean, right now we're in a position where none of that is defined. So, I mean, we're just going off of like nothing, right? I mean, because none of those tests and things that you have described are in the contract, right?
Because it's the law.
Right.
So like there's thousands of laws that apply to employees, and they're not in the contract because we're required to follow the law.
Okay, so I mean, in that case, like you would just follow the law, right? I mean,
right, but the way that language is in there right now makes it sound like even if something is potentially unlawful, we can't take action.
Okay, I mean, so if I were to reinsert that language and say, of course, the university can take action when that speech is unlawful, would that
I'd have to
address
see
your concern?
how you write it, because then you have to also take that into consideration with our disciplinary article, which we've already TA'd, and look at all that together. So, I mean, you're welcome to propose what you want to propose and we'll look at it.
Okay.
Can I ask, has there been like specific concerns to Candor about like, because we couldn't find anyone who had been disciplined around this. We couldn't find any, like we were thinking maybe there was a case or something that you were.
I think there's increasing concern with the new raft of laws that have come up. Okay. So yeah, I mean, I think that it's something that could absolutely happen, and we would like to have the protection in there before it happens.
Mm-hmm.
All right, we're ready
I think someone had a question.
Okay.
You covered it, Sikander.
Okay. Any other questions?
No, I guess we didn't talk about that last sentence in 9.6.
Mhm.
Specifically on political statements. I don't know if you had another reason for discussing that.
Oh, yeah. G is also free to engage in political activity so far as activities do not interfere with their obligations as teachers and scholars. Again, we think that to the extent that you're legally protected, that's incorporated in that statement in 9.1. If you're acting as a private citizen, or as an individual rather is the term it uses in line 8, then that's fine. I mean, why would you also then say it again? It seems to almost imply that there's a different meaning there. It goes beyond what we've already stated above. So what's the substantive difference? If you're allowed to engage in, speaking, writing, and acting as an individual without institutional discipline or restraint, and then you say again, you can also be free to engage in political activities so far as the activities not interfere with the obligations of teachers and scholars. Again, to Olivia's point of that does not include all of the tests necessarily that would make sure that political activity is protected. That phrase, not interfering with obligation as teacher and scholar, does not completely encapsulate all of the reasons for which engaging in all political activities that are conceivable would be protected.
I can understand. I think I think my question would be the difference between what an individual is. I think we already explained that is, you know, very much a legally defined, acting as an individual is a legally defined thing. Would, you know, being a part of like a political party and doing things as part of a group count as an individual action, or would it count as working on part of a group, even if it's like legal actions? You know, that's where I would like draw the connection between like being a part of a larger political action. Is that acting as an individual, or is it acting as part of a group?
Yeah, that's not, you're just like saying whatever is your opinion, it's like acting in concert with others.
Like
for
freedom of
political aims.
association?
Yeah, I mean,
Which you already have a right to do under the law.
yes, I mean, what we're trying to have is again, like protections in the contract specifically would say that you're allowed to do that and like the employer cannot, you know, threaten you about this.
Right, but again, going back to the specific versus the general, association, as Olivia said, is protected. This statement, political activities, what does that, I mean, the range of political activities, what does that mean? I mean, there could be
Okay, lawful political activity
as defined by.
laws, as you said so eloquently before, right?
Why don't you take, you can feel free to take a stab at.
Okay,
sort
we
of
will. I think we
encapsulating
will.
everything and we'll take a look at it.
We'll do it, yeah.
All right. Last one we have for you today is 4. So. And just to be open, I don't think we're close on this one.
She's asking for the link. Judy was asking for the link to bargaining.
Oh, who was asking for it? Oh, it should be the same one. Tell her it's the same one. Yeah, I'm not sitting here looking at my phone, sorry.
No, that's why I waited till there was a little break.
Yeah. You guys haven't changed the link, have you?
No, it's the same one.
Sorry, it's Dr. Travis was asking for it. None of us were watching, none of us saw it. All right. I don't think I have enough copies for everybody to have one, but there's 3. Like,
Do you want to share one? Or
Yeah.
we can share one and Austin.
Okay.
can share one.
all right, so there's probably 4 main points. I mean, there has been, in some cases, I think I counted a word that had 4 different colors in it. So this has been like, it's been a challenge. For the first time, I actually had to go through y'all's proposal, our last proposal, and the original language.
That's what I
because
did
it was
too, yeah.
so confusing.
Yeah.
But I think in summary, so I'm gonna say this with a caveat. I'm gonna focus on about 4 things, which are substantive differences that we still are pretty far apart upon.
Yeah,
If there are other small changes and I don't discuss them, it's not because I'm not trying to highlight them. It's because we've made so many changes to this article that I may inadvertently not identify one. So please, when we're done,
yeah,
please read through it thoroughly. And if I miss something and you have questions or whatever, because I'm not intentionally leaving something
Yeah.
out, but
I
It's
was gonna ask,
so
did you
hard to
notice
tell.
anything like that in my version?
I didn't.
Okay.
But that doesn't mean it wasn't there and I missed it.
Yeah, that's
Because
right, yeah.
like I said, I was reading all 3 at the same time.
Okay.
Go
I
ahead.
just wanted to know which color was the newest color. Is it blue that we're looking at?
I believe it is the sort of brighter blue. Because I think there's multiple blue colors. I think it's the brighter blue that matches the word may in 4.1C that is also highlighted. So that color blue,
Okay.
but that color blue also appears in here in other areas that are not actual changes. Because I think the track changes has run out of colors, so it's reusing them, which I think is part of the problem.
Thank you.
So, all right, so I think the first difference, major difference in terms of where we're still pretty far apart is in 4.1C. So here is our sort of back and forth on this one. We are willing to agree to the removal of the details of the letter not being grievable. But the balance of that is going to be that the word may is sort of what we want. If the word must is what you want, then you know those 2 things we feel are somewhat related. and we realize that that's something that we've gone sort of back and forth on multiple times. So I'm not sure if,
So what would be groupable then in that letter?
well, technically the whole thing now, because there's no waiver now listed. It's part of the contract.
Mm-hmm.
So by definition, I mean, I'll have Olivia correct me if I'm wrong, but by definition, if there's not something specifically called out, it would be part of the contract. So therefore, if you feel we violated the provision, it would be grievable.
Okay, keep going.
So that's the first one, not probably the most significant one, but it's the first one. The second one is, if we go down to 4.2 should be the same. So back in 4.3, I know we've gone back and forth about whether or not the 12-month appointment is a standard practicable appointment. I know we've talked about this. We're just not interested in having to prove that giving someone a 9-month versus a 12-month appointment has some sort of practicability standard. We're just not interested. We are willing to, the statement that says that we recognize the 12-month appointments provide job security for graduate assistants. We've agreed to that one, but we're not going farther to say that basically the default is if we meet a practicability standard that it's going to be a 12-month appointment. And I just don't see us getting to a point where that's going to be something we're going to be able to agree to. I think 4.4 is the same, that the one that says 4.4, which I think actually would be 4.4 in its current form.
Yeah.
Down in 4.5, you had suggested keeping CCL. You had brought up last time, like, where did that go? I'm not honestly sure what happened the last time around. I don't think it was our intention to delete that. I think I was intending to move it and then maybe didn't. So
sorry, which one are you talking about?
I'm in the new 4.5,
okay,
where it was about you guys being able to getting information about teaching
appointments. Yeah, you deleted
and it. Again, I don't think that, again, I thought I was maybe trying to shift it and then didn't just hit paste. So
okay,
we're fine with that. That's CCL.
Okay.
Okay, so now this is where we get to where we're probably going to have our biggest difference, just very frankly. So 4.6 was you had stricken, we had kind of reworked it. You had sort of stricken it, reworked it, we reworked it. At this point on 4.6, the statement, the explicit statement is a statement that's in current contract language, and we feel it needs to be kept in that point. In the context of the other changes that I'm recommending below, which are, again, a large scale rejection of sort of what GAU has proposed. The reappointment notice is the current language that we are reproposing in 4.7, that's CCL. So I know that you had sort of taken 4.7 and moved it and sort of adjusted it with a new 4.6 section, which was a combination of reappointment notice and non-renewal. We're not interested in,
or rather non-renewal and termination.
Gotcha. Yeah. I thought it was notice and reappointment notice and changes to appointment. Sorry. So the multiple, basically the contingent nature of non-renewal, that whole section, we're just not interested in getting away from. And I said at the outset of bargaining this article, we acknowledge that we have a very strong current status quo with respect to the nature of reappointment notice. And we acknowledge that GAU has very explicitly been interested in removing that and creating an expectation of multi-year appointments unless certain conditions are met. And the university position is just not going to move away from the current status quo, which is giving us pretty broad scale ability to non-renew, assuming that we meet these notice periods. So not that I want to fast forward and not give you an opportunity to comment, but I want to contextualize it with some of the things that are farther down below, if you don't mind.
Sure.
And that is down in, if you look at 4.9 from the current contract language to the present version, for the purposes of understanding how much has changed, I do think that it is worth acknowledging exactly how much additional language and work we have done in that section, specifically with, increasing notice periods, contemplating some of the other components, especially in A1, where we're taking on the responsibility of communicating changes in a more timely fashion. specifically with regard to in B1, which I think on yours, you would switch the letters to numbers and numbers to letters. So I think they switched back when I saved it. So just check that, because I think at 4.9, I want to say the other version was 1 and then A. And then for whatever reason, when I did my work, the way that it automatically numbers and bullets stuff, it does some wonky stuff. So down in B1, you know, talking about giving significantly more description with respect to B1 than it previously just had that single statement. You know, contemplating things of, you know, formal communication with a 30-day notice prior to the effective date of the change in the appointment, you know, reasonable opportunity to meet stated expectations. I realize that that's nowhere near what you all are asking for, but I do want to acknowledge that we have, from the original starting position, you know, we do believe that the university has made some pretty significant concessions. Again, I'm not saying it meets what you're asking for, but I do believe we have acknowledged and made some concessions from the current language. So I think, I mean, that's the really big one, is that section. When you go down to down in 410, I went through it several times. There are a couple of words that are different just because the way that we wrote the MOU was split into discrete statements. So we believe this says exactly the same thing as the MOU. I just want to make sure from your all's perspective that provision says exactly the same thing, because there's the use of some pronouns because it's all hanging together in a single paragraph. Our intention is that 410 is intended to say exactly the same and have the exact same meaning and impact that the current MOU did. We just want to make sure that that is also your understanding.
Yeah, I mean, and I said this in my comments as well. I mean, like, I think we're fine with the provision. I mean, we'll also see how these, yeah, I mean, so I think we're okay with it as well.
Yeah.
Again, that last sentence, it's something I forgot to mention with you guys last time, is, I mean, this was a thing we've already discussed a little bit at the table, is this final sentence that the hiring unit might not award a tuition waiver, right? So what happens in a case where someone thought that, or they have to register for credits to get their GA position, but then the department says, we're not going to give you a tuition waiver. So does that person have enough time?
So go ahead and say it again. So this is a situation where not because of their academic program, but because of their appointment,
right,
that they have for the summer,
right,
they have to register,
right,
and then subsequent to that, they discover that they're not going to get a waiver.
Yeah.
Okay, so our intention is in how does that conform? We thought that person is protected under the line that starts at the end of line 188, and that the hiring unit decision to award or not award a tuition waiver must be provided to the employee at the time the appointment is offered. Because we were trying to avoid that exact thing, because we didn't want someone to be like, oh, great, I have an appointment, I automatically by default and contract get a tuition waiver. And then they show up and they're like, oh, by the way, there's no tuition waiver.
Yeah.
I'm like, well, I wish you would have told me that before I registered for classes.
Right.
Because now I'm out the money, because now I don't get a tuition waiver. And the only reason I'm enrolled is because I'm doing this appointment.
Yeah.
So, I mean, I think our intention is that sentence should insulate, if it's followed, should insulate the person. But if that doesn't address it, let's talk more about it. I mean, I think
it does. I just like, I'm just not fully sure about.
I don't think it addresses the unit erosion issue on a greater scale. Remember, Jacob has talked a lot about, like, if we open essentially like a back door for categorizing people as 9 months, but allowing them to add in this summer and not pay the tuition waiver.
Right.
The departments would be incentivized to put people in as 9 months and then give them summer appointments separately from that without the tuition waiver. So they're kind of avoiding the 12-month contract, using a backdoor where they don't need to pay for credits over the summer.
Sure. Yeah, I think, and I remember him sort of bringing that up. I think what I would say to that is, I think a lot of that is going to wind up being dictated on the application market, in terms of when we're trying to attract, if, like, say, for example, if we started to do that and that wasn't on, like, for a particular discipline or college or area of study, if the standard across, the Southeast or the United States or whatever is that, they have access to a 12-month appointment, and, we have a department that thinks they're gonna sort of save the tuition waiver money, well, they're gonna have to compete with other institutions that may be saying, look, we're not gonna mess with that. We're gonna just offer the 12-month appointment. So internally, there wouldn't necessarily be a check, but I think there would certainly be an external check. And again, it would only affect, because it wouldn't be a basis for changing an appointment that already existed. Like if somebody,
Yeah.
like it would only be
Incoming.
correct.
Okay.
So again, my intention was not to gloss over the big change. So if we want to go back and talk about
Sure,
that,
yeah.
we absolutely can.
Mhm.
Again,
So can we just go back?
acknowledging how far apart we are on this, I'd say that
Yeah.
openly.
Yeah, we are. So for one, I just want to make sure in line 9, you did intend to keep that must, right? I mean, that's what would make the offer grievable.
Letter offer must include.
Yeah, we've changed this one.
Yeah.
This is the one.
But that's the
He's saying
part
but
that
up
would be
here.
grievable, I suppose. in
Yeah,
that term.
if your letter of offer didn't include that, they could prove that.
Or, I mean, those items themselves could be grievable, right? I mean, the initial stipend value, the
Well, the stipend amount
Yeah.
couldn't be grievable. But
stipend amount couldn't be grievable.
no, but I mean, like, if you got a letter of offer and it didn't include that, then that would be grievable.
So it could include an incorrect number for the stipend amount?
Right, so I thought you meant like they want to grieve how much they're being paid, but if
Oh,
like.
no, like,
Yeah.
as in,
I was
like, oh, no, no.
Why do you take the job?
Open the door that far. But yeah, no, yeah, it says. they
Don't
want
give me
pay.
any ideas. No, I mean, no,
Yeah,
that's not what I meant. I meant more like, okay, it says one number and you get paid
Yeah,
a different, okay.
Mhm.
Okay, yeah, I mean, yes, we're definitely very far away. I think, I tried to, when I was presenting last time, and I'm not sure if I did a great job of it. I mean, like, I think the biggest point here is establishing some level of job security.
Right, you made that,
And
I think you made that clear.
And
We
I
got it.
think, and I think you've also made it clear that you enjoy having the ability to kind of move us around at will. And I think that that's, I mean, I understand that view from your perspective.
It's just not an incremental, there's not a whole lot of incrementability on the point. In this particular component.
Why is that?
Because you either have the promise of future employment beyond the current term, or you don't. And there's not, even with the constraints that you've identified, from our perspective, it is a bridge too far to give multi-year. It's too far away from our current status quo. It's just too far away. It puts way too much more of the promise of future employment on the side of the employee, way more than what they currently experience.
On the employee?
Yeah.
What do you mean? I'm sorry.
Because the default becomes, the default switches from I have to be reappointed to the default effectively becomes I have an appointment for the entire term of my letter of offer.
Right. And then
that's not the current
which
status quo.
one do you think reflects more closely what people think actually is their employment status?
So I think I understand the confusion. We've talked about it many times.
Yeah.
The letter of offer has a multi-year term in it.
Right.
So one of the things that I did want to at least share for what it's worth was, the number of people, we're trying to pull some actual data in terms of the number of people that were actually termed. And since January of 20, we believe the number is 26 out of 4,200 a year. So again, that's little solace to the fact that the position is pretty far apart, but we don't necessarily think that this is something that we are like abusing. We don't think it's broken. We don't think it's a problem. And we absolutely enjoy the status quo.
When you say termed, do you mean terminated as
Yes.
in cut off?
Yes.
What
So-
about people who are just like casually non-renewed? Because I know a handful of them who've been non-renewed this year because the department like says, oh, we don't have money for you anymore, and yet they're bringing in new students or like.
Yeah, I didn't pull non-renewal numbers. I just picked term numbers. I just pulled term. I didn't pull.
How many did you
non-renewers.
say there were?
26.
26.
Okay.
Was that was one report. That was one query that I pulled from the class and comp folks. And they said that to the best of their ability, that is the number of termed.
Do you know why? Like, did you get the data?
There wasn't a
why
reason
they were
code. I didn't have the reason code. It was just total terminations. So that would have been people that were in the middle of an appointment that were forcibly separated.
Okay, mid-appointment.
Right.
Okay, we have a question here from Katie. She's a GAU officer. She's part of the party. Katie, go ahead.
Hi, yeah, I was wondering how does this play into departments telling incoming students that they're guaranteed funding for 5 years, especially when they're interviewing, like the idea that they're guaranteed funding for 5 years, but in our contract, they're not actually guaranteed funding for more than their current contract.
Yeah, I think it's a good question, Katie. And I think we've actually had that almost exact question before. I think we actually had it last year when we were bargaining. And I think that it's one of the reasons, quite frankly, that we feel it's very important to have an explicit statement like we're suggesting we put back in for 4.6, which specifically says that no appointment shall create a right, interest, or expectancy in any other appointment beyond the specific term. I'm not going to argue that there is not confusion. We've actually had some cases that we had to deal with before about that. It's one of the reasons that we want to clean up and make sure the language in letters of offer and letter of appointment are clarified. We want to differentiate between letters of offer and letters of appointment. And I think we acknowledge that there has been confusion, and there has been times when both students and in some cases members of departments are confused about the relationship between letters of appointment and letters of offer. I think we acknowledge there has been confusion.
Can we then have a statement in here that prohibits departments from giving those kinds of guarantees when they're interviewing students and accepting them? I see an issue here with having you talked about external checks, but if your department is saying that you have funding for 5 years, then there isn't really the ability for there to be an external check. But if the department is required to say, we actually cannot guarantee you the funding throughout your PhD, then that would allow for the external check that you were previously mentioning.
I understand what you're saying. Yeah, we can take a look at that. We'll
And
talk about that.
Also, I mean, going back to your point, I mean, yeah, I think we both acknowledge that this is an issue. And I think the way that we want to deal with it is like try and make the contract more like what people think it is. And I think how you want to deal with the contract, or how you want to deal with it is essentially saying, well, actually, it's not like that. And like, we actually don't owe you anything. And I think that there is like a middle ground there. I mean, like, so I understand that you know, the current way of doing things gives you a lot of freedom. And I think what we want to do is establish some level of protection for ourselves. So, I mean, I think we'll take it into account what you said. But yeah, we are definitely far apart.
Yeah, I think at its core, and I would ask Robert to speak up on this amount as well, because we spent a lot of time talking about it. I think at its absolute like core kernel, like the core kernel of the center of the whole thing is right now the status quo allows us by a discrete date us to be able to effectively non-renew a GA without cause.
Right.
Sort of at its core, there's a lot of other information here, but at its core, that's kind of like the fulcrum of the whole thing. I think that is between where we are different. I think that's probably the biggest place where we're separated, because I think maintaining that status quo in terms of the ability to have a date at which we don't have any sort of causal responsibility to make that decision, I think is probably at the center. Robert might,
yeah.
I mean, because we talked about a lot of these pieces, but I think that's.
Is there something from a manager? Oh, sorry.
That's just consistent with how non-renewals work for Teams employees, for non-tenured faculty employees, or it's an issue of time notice, not an issue of whether or not you can do it.
Yeah, well, maybe I think the question I wanted to ask is like, is there a difference from your perspective from the thing about reappointments versus changes to appointment, right? Like the way it is currently, like if you want to terminate someone with an existing appointment, you do have to have a cause, right? So, I mean, from the management perspective, what is, functionally, what is the difference there?
Ask your question again.
So like, I mean, what we tried to do in the last proposal was trying to establish the same reasons for
Yeah, you put them
non-renewal.
together.
Yeah, and more or less the same timeline, though there are some differences there. And so, because for us, functionally, both of those things are the same. Whereas, I mean, from your perspective, is there a reason why like the reappointments has a different criteria? I mean, why is it that a better kind of system for you than? Yeah.
So I think I understand your question.
Yeah.
I think the current language allows us to sort of break the entirety of the letter of offer term into components.
Mhm.
And those components can't be any greater than a year.
An appointment
Period. And then, we have a responsibility to give notice whether or not the reappointment will be issued or non-renewed by a date certain. And it provides the university with considerably more flexibility than if we were to say it's a 5-year, multi-year renewable contract. I mean, I'm not familiar with just about anywhere that sort of has that baked in within the rest of our employee. It's actually the way that you proposed it. I don't think you intended it to be this way, but the way that you proposed it, it actually gave, in some respects, GAs had more rights than faculty did in some respects, which again,
in what way?
Because we have the ability to non-renew them in a very similar way to what you all have currently as your status quo, not for tenured faculty,
Right.
but for untenured faculty. There's a notice period, and then we were able to non-renew them.
I mean, right. I mean, when they get a letter of offer, do they get told that, you might be employed for 5 years, but actually your reappointment only occurs on a year?
No, the letters of offer are pretty clear that it's an annual, we're
Okay.
subject to renewal on an annual basis.
So there is a difference as well, right? I mean, in the sense that they're not promised 5 years and then get 1 year.
So yeah, I think the difference is the difference between the funding being available for a finite period of time and then the employment being guaranteed for that same funding time. I think that's
Right.
Like
So
you said,
actually,
practically it's not different, but
maybe that subtlety I didn't explain too much last time, but it didn't actually guarantee the full 5 years the way I wrote it last time. It was just that for a reappointment to not occur, right? Then say you're citing the reason of not enough funds, all right?
right.
Then in order for that to occur, that you could still not renew or terminate that person.
Right.
But you would have to
Subject to
pay
conditions.
severance, yeah, whatever. But then you could actually terminate that appointment, right? I mean, it's not that like you can never, it's like for those 4 reasons, you
Right.
can terminate that or
Yes.
not renew.
Right.
And so, I mean, it's not actually guaranteeing all 5 of those years, right?
Right.
It's guaranteeing the first appointment and then like the first 20 weeks of the next appointment, or whatever, right? I mean,
Right.
But only if one of those 4 conditions is met.
Right. The
Only one
default,
of
the
those.
Yeah,
default
so
becomes the entire period.
That's the issue, is that there's non-renewals for hundreds of different reasons.
Mhm.
Again, it's kind of like, and that's where we have the discretion to decide, we're just gonna non-renew, and it doesn't matter if it's one of these 4 reasons or not.
okay. I don't know.
It's kind of the general basis of at-will employment in the state of Florida.
Can I ask my question that
Go
I
ahead,
keep
go ahead.
bringing up? So I'm a 9-month employee.
Mhm.
I'm a 9-month GA, but I sign a letter of appointment every single semester because I am a TA and I will be an instructor,
Mhm.
right? And so every semester I say, I'm working with this professor and I sign that letter
Mhm.
and they call that a letter of appointment.
Mhm.
Does that mean I can be non-renewed within my 9 months?
So in the current contract language of 4.7C, 1 semester appointments can be non-renewed within 45 days prior to the expiration of the existing appointment.
But
Yeah,
I'm
the
in-
confusion is,
Yeah,
it's,
I'm a 9-month GA though. My letter, the 1 semester letter that I signed
Mhm.
says that I'm a 9-month GA.
Okay.
And so I have a conflict between my appointment being 1 semester and
Oh, I
my
see what you're
appointment
saying.
being 9 months.
I see what you're saying. So are you a 1-year, 9-month appointment versus are you a semesterly appointment? That's your question.
Yeah, and so my question is, can I be non-renewed in December even though I'm a 9-month employee?
Because if you're a TA, right, like,
Yeah.
it's a new class every semester.
Well, that's what I was
New
gonna
semester
ask,
every
like, what
semester.
changes in those 2 letters, just the classes that you're teaching?
Mhm.
It's almost like,
An assignment as opposed to. an
that's exactly what I was
appointment.
gonna
hate to
say, I think, it's like, I don't wanna add like another level, but it's kind of like with our faculty, they get an assignment each year, you know, because, you know, and it's almost like what they should be giving you is, you have a 9-month appointment, and it's almost like what you should be getting is your assignment for the 2 semesters that you're working, as opposed to a new letter of appointment for each period.
Yeah.
Would that not be covered by the new language of 4.9A in terms of a substantive change? I mean, the university shall provide a notice to an employee whose employment, unit assignment, or supervisor changes?
Yeah, that's maybe,
So if you're teaching in the fall and you're gonna be teaching in the spring.
Your appointment hasn't changed, but your assignment has changed.
But I do know people who have been non-renewed, who I'm pretty sure are 9-month GAs who've been non-renewed mid-year. Do you see what I, like?
Yeah, we would have to
Yeah.
look at the appointment letter.
Which would
I
essentially
think
be a,
we should probably take a look at the specific appointment letter.
in which case that would be briefable, right? Because that's a break in the appointment if they're a 9-month employee.
if you have a 9-month appointment.
If you have a 9-month appointment, not a semesterly appointment. I think.
But I
there's-
mean, I would say, you know, I mean, it's very common in biology as well, like you're on a 9-month appointment, but you
Right.
get these. And I mean, I think the average person doesn't know, it's like.
Yeah, they're not
so,
thinking
yeah.
about it.
I was just looking from journalism, we would do the annual letter of appointment, but there was a line in there that said there'll be an addendum in spring
Okay.
to change your assignment. And then
Mhm.
say, this is
Yeah.
an addendum to your letter of appointment, you know, your spring teaching assignment.
I get a full new letter,
Yeah,
like through
that's- yeah.
DocuSign that's called an LOA.
Sounds like.
I have a 12-month one, and I get one every semester.
Mhm.
Yeah.
What college are you in?
Material science and engineering.
Engineering, I was gonna say, because I believe that engineering actually breaks every single appointment into semester, like college-wide.
Yeah.
That's their
But
standard.
Every single one of them says I'm a 12-month.
Yeah.
Gotcha. Yeah.
But I get a new one every semester.
Okay.
And my department also told us at orientation that we're guaranteed funding for the 5 years.
Mhm.
Within our letter of offer and verbally. So,
Yeah, I feel like in psychology it's the
Appointment or
same
offer?
thing.
offer. So our offer, they told us this guarantees you funding for 5 years.
Yeah.
And we've had 2 people, well, 3 people, that not happen for. In the past year.
Okay, sorry.
I think it-
No, I
okay.
was gonna say that's the same thing for psychology that I am on a 9 months and I get every semester I get an LOA.
And I get an evaluation at the end too, like as if it's a completely different appointment.
We can talk about
Like
that.
I don't get well, I do get an annual evaluation, but I also get a semester evaluation from the professor who I am for.
And see, for me, I don't get nothing annual evaluation. My evaluations are every semester that I have to meet certain criteria and then sign off on every semester, even though my appointment on the books is 12 months.
Same.
There feels like we have a very large disconnect between what's in the contract as it
I think
exists in PTL and what's
appointment
in practice.
assignment is really important.
Yeah, that's, I
Yes,
mean.
yeah.
I think
So
Discussion in the very first.
It
really did.
And that might be
Yeah.
helping draw this divide that we're having as well, is because we are all meeting with different expectations from our department that are different than what's in here. And that's why, I mean, if we're being promised 5 years and then we come in here, we're obviously not being promised, we need to make that clear on all levels. I had 2 notes here.
Yeah.
The first was, I mean, if you could pull numbers on non-renewal, obviously I don't know if you're willing to share that stuff, but that I think would be very beneficial in letting us know how widespread this sort of problem is. Especially, I guess, non-renewals at a semester mark, and how they're put
I
in.
could try, but I'm not so sure. I'll give it a shot.
Yeah, I mean, even if it's like a subset, we can see like in certain departments how bad it is. And then the second thing is we keep making comparisons between like faculty and other departments at UF, which is fair in most cases. I think in our case, I also want to make the point that while we are working for UF, we also have the other side of the coin where we are investing in a multi-year degree. And so we are here, we're expected and hoping to finish that degree And having a non-renewal doesn't just set up, and mess up our income and where we're doing things, but also messes up, our planning for the next 5 to 10 years. And it can be a very huge burden because then you have to make a decision. Am I moving back and giving up, or am I now obligated to continue staying here for my degree? And that's where these kind of semester or yearly long things also can create a burden on, if the university isn't willing to commit to having me here for the length of my degree, why am I committing to being here for the length of my degree?
All right, thank you for that. Other thoughts or questions?
What's going on with the healthcare article since wasn't
Yeah,
being
sorry,
brought today?
I said at the beginning, Brandon, before you were
I
on.
missed it. All right.
Yeah, my intention was to come here and bring that today, and unfortunately, there's one component that I was not able to get sort of all buttoned up. So my
All right.
intention, hopefully, the next time we get together, I will be able to have that. That's my hope.
Great. Okay.
You should have told them we keep
Yeah, we TA'd it before you got on.
No,
Yeah.
that's happened. No, that's not what happened.
We don't want to do
Uh,
a few skins. It makes more sense the way
Do it all
we
at
have
once.
everything.
Do you know if you expect to have any of the other larger ones ready by the next time we meet? Because we have a couple-week break, but I know those are obviously for busy reasons.
So I think that let me pull up the scorecard real quick.
So I think you have non-discrimination, you have Article 10.
Yeah.
A lot of those bigger ones are going to require more time and effort on each side, so. What?
Do we have workload or do they have workload?
No, you guys have work.
I think we have workload, yeah.
Workload's on our side right now.
Yeah, so after today, I think the only ones we have are 3, 10, 12, and 13. And you guys have 4, 5, 7, 8, 9, 16, 19, 23, 24,
Well,
25.
16 we just did today.
Oh, that's right. I'm sorry.
Yeah.
I apologize. Yeah. So, yeah, I mean, I think all the language ones were fine. And I mean, we are working on, we're working on 9 and 10 and are working on 10 and 12. And I think even you guys would acknowledge that the new version of 13 that we got from you guys was pretty fundamentally different from the ones there was a lot of new stuff in there.
No,
I mean,
that's what
there
I'm
was
saying.
a ton of new stuff in there.
Just to check in on.
So,
Okay.
and it wasn't light fare.
No.
Yeah, I mean, the thing that I will tell you that, and I had said this before, if we are going to be coming to a session and not having at least a proposal or two, I will let you guys know, like that.
Right.
I mean, I think we've been pretty good about making sure that we've always had something, but to your point, as we get sort of towards the end, when it really kind of gets down to, I don't know what has been in the past, typically in all the contracts I've previously settled, normally salaries is probably the last thing that typically you do. I don't know if that's been the practice here, but I assume at some point we're going to be probably down to, 10 and 12 and 13. I mean, we're going to be down to probably that.
Right.
So.
All right.
All right. Y'all have a good weekend. And if you're off, a couple weeks.
Thank you.
Yeah, thanks.
Yeah.
Good luck with your finals if you still have some.
Yeah.
We're finding somewhere to go out to eat.